Any mention?
May I please, Your Lordship? Your Lordship, I beg to mention item number 15, Your Lordship. I have taken consent from the other side. May it come after 2 weeks, Your Lordship?
No objection. On prayer made on behalf of the petitioner, district 2 weeks.
Highly obliged.
Yes.
Supplementary causeless. Item number 1.
May it please Your Lordship. Lordship, there is an application under Rule 6, my Lord.
Revision.
Over District Council, yes, revision, my Lord. So we are aggrieved by the impugn order passed by the learned assistant judge, my Lord, District Council Court, my Lord. So an application, my Lord, was filed by us, my Lord, under Order 7, Rule 11, my Lord, because they have filed an application for money suit, my Lord, after 10 years.
You were a defendant.
Yes.
In a money suit.
In a money suit, my Lord.
You filed an
Application under Order 7, Rule 11, my Lord. On the ground that it is barred by limitation, my Lord, because they have preferred the money suit, my Lord, after 10 years. If Lordship comes to their plane, my Lord, page 14, my Lord, Annexure 1.
Yes.
The relevant portion will be at para 5, my Lord, page 15.
Yes.
So it says, my Lord, that the plaintiff agreed to the request of his uncle and gave a sum of rupees 7,50,000 at Salsala on 19/2/2013 in the presence of Sri So-and-so and James Tirmai, the place where he was stationed in lieu of the election purpose for a land situated at Asipara, Nokat, and thereafter sum of rupees 2 lakh at his residence at Kalaza Road, Tura, and accordingly, late so-and-so gave an acknowledgement received for the said amount. Accordingly, the plaintiff paid an amount of rupees 9,50,000 in total for a 5 bighah plot of land from Asipara, Nokat, and on 2 occasions, the witnesses were also present while the payment was being made to Atul C. Marakmal. Thereafter, my Lord, if Lordship comes to page 16, para 12, my Lord,
Yes.
it says that the cause of action arose from 19/2/2013, my Lord. And they have filed this application only on October of 2023, my Lord. The mere reading of the plain, my Lord, would show.
No, the thing is that it is the date on which money is paid.
Yes, my Lord. So money.
It is not that the date on which refund was due.
No, it has to be from the date when the money was
It
paid,
has
my
to
Lord.
be from the date on cause of action.
Yes, my Lord. The cause of action it's on 19/2/2023, my Lord. So they have.
But then it says paragraph says payment was made on 19/2/2013.
Yes, my Lord.
Then that means the refund on some other day.
Some other it was not there, my Lord. They have simply enclosed a type copy, my Lord. Please come to receipt.
It is with regard to payment. It is not something like a lending or borrowing, isn't it?
Yes, my Lord.
It is a payment for proposed sale of land, isn't it?
Yes, but that land also was not in.
Then the question of cause of action will be different. It cannot be taken from the rate of this. See, today I borrow money from you with promise to repay it within 3 years.
Lordship.
After 3 years goes, and then your limitation will start from that day, from when default starts, not on the day on which I take money from you. Anyway, we will issue notice. You will see to it.
Lordship.
That is what. But then the statement made in paragraph 12 gives you a case.
Lordship.
Paragraph 12 of this plea.
Yes, my Lord.
Where they have specifically stated
Stated that, yes, my Lord. That is my case, my Lord.
That is what it is. We'll just see what happens.
Lordship.
Issue notice.
Lordship. Meanwhile, my Lord, if the proceeding may be stayed, my Lord, because my Lord, if I'm successful, my Lord, then it will become a futile exercise,
If
my
you are
Lord.
successful, then entire suit will go.
Yes, my Lord. But meanwhile, they're proceeding with the matter, my Lord, so that is why.
There appears to be some confusion in this suit itself.
Lordship.
Now, if the statement made in the suit is to be accepted in face value, then That is
See,
something
my lord,
you skipped. Paragraph
I-
5 and paragraph 12 seems to be contradictory. So that is where we have to see the law. What would be the
Yes,
position?
my lord. The conduct of the assistant judge also, my lord, will show that when the matter was still pending, my lord, they have filed an application under Order 39, Rule 1 and 2, my lord. They have attached a property, my lord, and passed an order for status quo also.
Is it?
Yes, my lord. If lordship comes to,
But then have you challenged that order also?
we are challenging that order here, my lord.
Here in this page?
Lordship.
In this
Because
revision?
apparently, my lord, that is.
Anyway, let us come
Lordship.
to one first. We'll just see what happens. We'll issue notice and just see. Yes, heard Mr. Ajimani, London Council of the Petitioner. Issue notice or returnable in 3 weeks. The petitioner shall take steps for service of notice upon the respondents within 2 days. List after 3 weeks. We'll see what happens on the next day.
Lordship. Meanwhile, my lord, if the proceeding may be stayed, my lord, because.
Civil suit will take some time, isn't it? Why should to disturb it? Let us see.
Lordship. Hello, Brishmal.
Daily list, item number 1.
There is an application for challenging the maintainability of CRP, my lord.
Yes.
Lordship, before coming to that, they have filed miscase number 10 of 2025 in CRP 34 of 24.
Yes.
However, Your Lordship, in the first para itself, an application challenging the maintainability of civil revision number 35 of 24.
Was there any requirement to bring it by filing a miscase?
My lord,
You filed your objection to the maintainability of the main case. Why a miscase?
my lord, my lord, on the last occasions I have taken leave of my lord.
For filing an objection?
Yes, yes,
Filing an objection doesn't
Objection.
mean by a miscase. Opposition is the main case.
Of course, that is there, my lord.
Why
but
it is a separate miscase? You make miscase, you make it complicated. Now you have to give him again chance to file a shock cause, and then it will become a hearing within a hearing.
my lord, but only one very short point is here, my lord.
Yes.
If very short point is here, my lord. I was my only short point, my lord. What my friend has pointed out is a small typo mistake that can be rectified, my lord. It's only a figure of 4 and 5, my lord. 34,
But
35.
still,
That's all.
Your Lordship, even in the prayer portion in page 4, Your Lordship, they have to dismiss the civil revision number 35 of 24, whereas this is civil revision number 34.
You veto this petition, file an objection in the main case.
In the main case, my lord. My lord, I can do that, my lord.
Do it. It's not required that.
My
Why
lord.
should you have a miscase on the question of maintainability?
My lord,
That also something not very correct.
my lord. I can do that, my lord. Yes. Withdraw this application and file.
Learning Council for the parties in the miscase. One prayer made by Mr. P. Evan, Learning Council for the applicant. On the prayer of Mr. P. Evan, on the prayer of Mr. P. Evan, the applicant is allowed to withdraw this application with a liberty to raise, with liberty to file an objection with regard to the maintainability of the
Of the civil revision, my lord.
of the main CRP number 34 of 2000.
34? Yes, my lord. 34 of 20.
That will let him. So everything will be corrected.
Yes.
What you say that also will be corrected.
Your Lordship, item number 2 is CRP number 35.
Anyway, then in the main case, you just say how much time you will take.
My lord, 2 weeks' time.
Yes, as per for by Mr. Evan, Learning Council applying for the respondent, isn't it?
Respondent, my lord.
Further 2 weeks time is granted for filing an objection.
My lord.
This is in the main 34. And then what about the other matter?
Similar.
It is similar matter.
There
my
also
lord.
is the miscase.
Same party.
Yes,
my
they have
lord.
filed a
There also you
miscase.
filed a miscase.
Yes, my lord.
So then same order in the miscase.
Yes,
in the
my lord.
other case also, and the same order in the.
Yes, my lord. All right.
Highly obliged.
Item number 3.
Yes.
Yes.
May I please, Your Lordship?
Yes.
Lordship, service upon the respondent number 2 is not yet completed, Your Lordship. I'm just,
You were supposed to file an affidavit, service affidavit.
yes, Your Lordship, but as per the portal, the post office portal, it's not delivered yet, sir, Your Lordship.
So
So,
what is to be done?
waiting for fresh steps, Your Lordship.
Okay. Are you sure the address is okay? The address which you have given.
Yes, Your Lordship.
Okay. There is there is no report of service or delivery of notice upon the respondent number 2. Stop. The learner counsel of the petitioner submits that it appears that the notice could not be served on the respondent number 2, and prays for allowing him to take fresh steps for service, fresh steps for service of notice upon the said respondent. Stop. Prayer allowed. When shall? How long?
After 2 weeks, Your Lordship.
Steps to be taken within
3 days,
3 days. This is met after
2 weeks.
2 weeks. Yes.
Apply.
Your Lordship, interim order may continue, Your Lordship.
This is an interim order.
In the miss case,
Okay. The message just say main with the list with the main writ petition.
Let the case be disposed of, Your Lordship, until further order.
Is there any private party here?
Private parties?
the complainant, Your Lordship.
Yes.
That is what. So that
Only
cannot
the
be-
liberty may be granted.
Let it remain. Let us see what
Your
happens.
Lordship, ask Your Lordship, please.
This is matter with the amendment petition. The interim order passed earlier shall continue till the next date. Let us just see once
Lordship,
they appear
yes.
then.
Apply, Your Lordship.
5.
Yes.
Please, Lordship, I have brought some compilation
What is
of
this, Mr.
judgment,
Case?
Your Lordship. Yes,
What is this case about, Mr. Sangma?
this is regarding
Whether
the
appeal lies or the revision lies. It's a case of acquittal. So whether revision lies or the appeal lies.
I have prepared some judgment, Your Lordship. This is a compilation that I have prepared. It is there, Lordship, where I will.
Yes.
Yes, Lordship, on the earlier occasion, that query was whether the revision can be filed for this noble court against the acquitter, or the order passed by the judicial magistrate per class. So that was a query. So to answer that one, I have done some research. Actually, that's a judgment.
Just
Actually, I'm
show us.
placing.
Is there any decision which can be, which says?
Yes, Lordship, I'm relying on this judgment, para 13, the pass, that is at page. Page 3, para 13 is there, Lordship. It's my compilation. 13, 14, 15, 16, and 17. I just say, if Lordship may allow.
Where would be the relevant part? Just tell us. Where?
This is 13, my Lord. 13. And
Yes.
13. May I read, Your Lordship? There will be a serious miscarriage of justice in the course of criminal trial if the statement were not to be marked as an exhibit, since from the form of basis of the registration of the FIR, the order of the trial judge cannot, in these circumstances, be treated as merely procedural or of an intellectual in nature, since it has been potential to affect the substantive course of the prosecution. The revisional jurisdiction under 397 CRPC can be exercised where the interests of public justice require interference for connection of manifest illegality or prevention of gross miscarriage of justice. A court can exercise its revisional jurisdiction against a final order of acquittal or conviction, or an intermediate order not being interlocutory in nature. In the decision in Amarnath versus State of Haryana, this court explained the meaning of the term interlocutory order in section 397 Brigade 2 CRPC. This court held that the expression interlocutory order denote order of purely interim or temporary nature, which do not decide or touch upon the important right or liabilities of parties. Hence, any order which substantially affect the right of the parties cannot be said to be an interlocutory order. Speaking for a two-judge bench, Justice Murtaz Fazar Ali observed, it is to us that
We are not concerned with the question of interlocutory order here. Here it's a case where final judgment had been pronounced, which resulted in acquittal. Now you want to challenge that acquittal, isn't it?
yes,
And you have preferred this third party revision. Now the law says where appeal is allowed, revision is barred.
yes.
Okay.
Lordship, another judgment also is
No,
there.
just tell us, how can it be? You are trying to establish something which is barred by law. That is what the problem. That is what the problem is.
No, here, Lordship.
This is an order of acquittal by the ministerial court, isn't it? In normal courts, the appeal will lie to session judge. And so far as the amended CRPC is concerned, the victim has the right to file an appeal. So we do not know why you are here in the revision.
Yeah, Lordship, another that even the victim also I'm the informant. The informant also have the.
Give us something direct to the thing. you
Yes,
see.
Lordship. This. The second page. That is para 21, 12. Para 12, my lord. This page 20 of the judgment is there. Another judgment I have said it. This is different, but in the compilation it is page 20.
Just a minute.
Para-
Just a minute.
Lordship.
See, this judgment, the very first judgment, which I have relied upon, it has nothing to do with the final pronouncement in a criminal case. It is totally on different issue. Okay, what is the second decision?
Yes, Lordship, that is para 12. Lordship, it is page 20 of the compilation. Page 20, then the.
Yes. Paragraph?
Para 12, my lord. The section 397 of the court vests the court with the power to call for and examine the record of an inferior court for purpose of satisfying itself as to the legality and regularity of any proceeding or order made in case. The object of this provision is to set right pattern, defect, or an error of jurisdiction or law. There has to be a well-founded error, and it may not be appropriate for the court to scrutinize the order, which upon the face of it bear a token of careful consideration and appear to be accordance with law. If anyone look into the various judgments of this court, it emerges that the revisional jurisdiction can be invoked where decisions under challenge are grossly innermost. There is no compliance with the provision of law. The finding recorded is based on no evidence, material evidence is ignored, or judicial discretion is exercised arbitrarily or frivolously. There are not exclusive
This
classes.
is also which way it helps you.
Para 20, my
Mr.
lord.
Sangma, have you bothered to read the provision of section 401 CRPC?
Yes, we have read 401.
You probably may not have to look for any decision of the apex court.
Yes, 401. His lordship, read your lordship, it is 401.
See, so 401 sub plus 4.
Will the order of this court an appeal lies and no appeal is brought, no proceeding by way of revision shall be entertained at the instance of the party who could have appealed.
Yes. So anything more you need? Can there be a more clearer provision than that?
No, your lordship, here I am the victim, your lordship. The state.
So you could not have filed an appeal. Please read this provision again, sub clause 4. What does it say? A party which could have filed appeal and then read it with. This is one thing we do not know. Which way you read the.
Where under this court an appeal lies and no appeal is brought, no proceeding by way of revision shall be entertained at the instance of the party
Who could have appealed.
who could have appealed.
Now come to now section 372 CRPC. See proviso, new proviso. Now this court has to make research for you.
372. No appeal lie unless otherwise provided.
Yes.
No appeal shall lie from any judgment or order of criminal court.
Come to the proviso. Come to the proviso. Provided that
the victim shall have a right to prepare an appeal.
Is that all right? You have a right to prepare an appeal. So read together now. Now 401 sub clause 3 and it's enough. You see, court is not there to teach you things. Hold it. Are you insisting or you'll be withdrawing it? It's up to you.
Your lordship, and
There is nothing more is needed, you see.
on the other court, your lordship, there's similar kind of things was filed appeal.
So as any decision where
yes,
final decision against
yes,
convict.
I will just complete this in the page. I'm trying to show the page 23 of my compilation. The judge para 20.
You are not giving us any judgment which is to the point. You are talking about the scope of revision. We know it. We know it.
No, here the case is actually the error of that. This one is actually even while trying the cases, the judicial magistrates have not recorded the evidence properly.
We will pass order. You go. You challenge it. Just okay. Hard, Mr. Petitioner. Learned counsel. This will be in the. Yes, Mr. Abraham, you want to say something?
This there's no provision for revision in the acquittal, in case of acquittal.
You just tell us which paragraphs you are relying on this.
I'm relying this section 419 of the BNS. 419 and
419 of
419 of this BNS and this
what is
422 or 442.
422 is this thing
442
corresponding to 401.
Yes, Lordship. That they said that
This is a petition under new this thing.
yes,
528.
yes.
This is an application under 528, isn't it? Not
No, this is under application. This under application of this. They file under application of 438. Talks about appeal in case of acquittal. 419 talks about appeal
419, that
in
means
case of
corresponding
acquittal.
to 378.
378, yes, I think.
That is all right, 378. You see, there cannot be a dispute that the victim has a right to appeal after the 2019 or 2020 amendment, isn't it?
There's no
Now
dispute.
the problem is that whether we can entertain this revision in spite of, you see, like a petitioner having a remedy or filing an appeal.
Yes.
Now,
And
so far as 401 or corresponding to 419,
419, yes.
yes, subclause 4, it makes it clear where there is an, you see, like right to appeal, and the no appeal has been preferred, then no revision should be entertained. So that there is a clear bar. But in spite of that, we do not know if he has any other decision to show it that 401 subclause 4 will not be applicable. That is okay.
And
He is taking this code to some other things. He is taking this code to 397, the scope and all. That
And
we know that will come. But then if the bar of 401, how will overcome that?
And 442, Your Lordship, subpara 3. Nothing in this section shall be deemed to authorize the High Court to convert a finding of acquittal into conviction.
That is all right.
So he come with a prayer that to set aside the order of acquittal. So even if the
Right now we are not going into that power of the High Court.
yes, Lordship.
Whether in case of because you see, like from acquittal converting to conviction, High Court has the power.
But
Definitely that has the power.
That is
we
in
are
case of
we are
appeal,
right
but
now
not-
concerned with the, you see, like whether he has right to file or not.
Yes. Only in case of appeal, the High Court has the power to convert into acquittal into conviction, but not in case of revision. The High Court can convert acquittal into conviction, Your Lordship.
Okay. If you want us to pass an order?
Lordship, give me a chance. Next time I will withdraw. I just get
No,
instruction.
there is no question of withdraw, Mr. Sangma. It is about appreciating law. It is nothing. You see, if law doesn't permit anything, this court also cannot help you. Please be realistic with that. And this court want to do something, do not want to do something, you see, which is not allowed by law. Now, how do you overcome that section 419 subclause 4? That is, you just show us and then we'll just say. There's a bar, specific bar, put in CRPC, okay, or BNSS, okay, whatever the case is. How do you overcome that? That is what. You do not have to give us any decision on the ambit and scope or the power of the code under 397. We have fair idea about that. We are on the question of maintainability. So that is what we need.
We'll withdraw it, Lordship. Maybe just withdraw it, liberty to file. I will approach the appropriate forum and
See,
file a
if
proper
you are
application.
convinced that revision will lie, nobody can force you to withdraw. Even the court also will not force you to withdraw. There is no question. You have a right to prefer the petition. Court may entertain, court may not entertain. That is within the discretion of the court. Okay. And please concentrate on that line. Instead of you see concentrating on the line of the scope and of ambit of power under 397, please concentrate more on 401 subclause 4. That bar. Read with section 372. That victim's rights of filing appeal, which was incorporated in CRPC by J6. So how do you overcome that? That is what. We'll give him one more. How much time?
After 1 week, my lord.
Just prayed for by Mr. P.T. Sama, learned counsel for the petitioner. This is matter. Oh, this will be in the miss case. Order will be in the miss case. As prayed for by Mr. P.T. Sama, learned counsel, appearing for the applicant. This is further 1 week time is granted. To address the court on the question of maintainability of the revision petition. List accordingly. Just
Hello, Bless Your Lordship.
Much more
Second
lordship.
way.
Yes, counter affidavit.
Well, I need some more time, my lord, in this matter. There is a problem going on in the district council, my lord. They are holding strike, my lord. And my
obstructing
friend's
you.
client is leading the strike.
No, I'm no more in service. He's lying, Your Lordship. Otherwise,
I'll produce the evidence on the
Lordship,
next
my
case.
small submission.
He is filing the case, and on the other hand, he is preventing.
I'm
you
no
from-
more in service. How can I will obstruct?
Very, very unfair.
Lordship, it is just a making. And Lordship, this is a very clear case because among everything it is here only. Because there is nothing to, because this is their document. Whereas Secretary Executive Committee have issued the amount which I am supposed to get is 22,70,990. It is their document only. They have assessed. There is nothing to, it is very
But then
clear
they have
cut
to, you
case.
see, even for signing the check and all, they have to enter the office, isn't it?
But my lord, Viran Purchandra is blaming me because I am no more in service. I am already, I'm still at home.
He has realized,
So
my lord,
what shall
whom
we-
I am indicating to.
Now tell us, how much time shall
3
we?
weeks, my lord, maybe.
Mr. Sangma, let Sangma say, he may say how long the strike will continue. Yes.
After 2 weeks, my lord.
3
Because,
weeks, my lord. As
okay, okay, no problem. No.
We can give him, but then the
Yes,
whether
Lordship.
situation will permit or not, that is the main.
Lordship.
Okay, just like one prayer made by Mr. S.J. Learned Counsel, appearing to the respondent. Further 3 weeks time is granted for filing counter affidavit in this matter.
Highly obliged.
Much blessed, Lordship.
Please take on it.
9,
May I please, Your
Yes.
Lordship. Your Lordship, bringing for some time, Your Lordship, to file affidavit, Your Lordship. For all the respondents.
This is pensionary benefit.
Yes, Your Lordship. No, Your Lordship, promotion.
They revoke my promotion.
Promotion, serviceman.
Promotion, ma'am. Yes, Your Lordship.
You are representing all the respondents.
Yes, Your Lordship.
There is no private respondent.
No.
Okay, one prayer made by M.S. Aidunga. Mandate G appearing for the. You are there.
I'm running from court to court, Lordship, sorry.
Just record the name. Further, how much time?
2 weeks time, Lordship.
Further 2 weeks time is granted. Oh no, you see this last occasion was for 2 weeks time is granted for filing counter affidavit in the matter.
Much obliged, Lordship.
Yes.
Item number 10,
Yes.
Please, Lordship. Your Lordship, and for respondent 1 to 3, Your Lordship, state respondent praying for some time, Your Lordship, to file our affidavit.
Lordship, respondent 4 is yet to enter appearance, Your Lordship.
Okay. There is no appearance for the respondent number 4, isn't it? Service has been affected.
Service, I have already, Your Lordship, taken steps.
Okay. None appears for the respondent number 4. MSGC Marbo is present on behalf of the petitioner. The news is paid for by MS I Lingua, Learned GA, appearing for the respondent number 1, 2.
1, 2, and 3, Your Lordship.
How much time?
2 weeks, Your Lordship.
2 weeks time is granted for filing counter affidavit.
Much obliged, Your Lordship.
11,
Lordship, here I pray for some more time, Lordship, to file my counter, Lordship.
Yes, one prayer made by Mr. SSC Learned GA, appearing for the state respondents. 2 weeks time is granted for filing counter affidavit in the matter.
Must.
hearing. Item number 12,
Oh, I'm number 2.
Yes.
My lord, this is that matter, my lord, where we have challenged the inquiry report filed in a departmental proceeding, my lord. it's a jailbreak case, my lord, and we were stuck at that point where, my lord, we had referred to the order dated 4/3 of 2024, passed by this honorable court. And my lord, there was a direction. There was a direction to the government to have instruction pursuant to that order, my lord.
Lordship, in the last date, this issue was raised again, and we thought we have made a submission in Lordship. We'll go on merit. एक चेक कर लेता है फिर हम अच्छा से वैद्यनाथ रिकॉर्ड पंचम वैद्यनाथ वो इम्पोर्टेंट
Now, the suggestion was basically to extend the benefit of pension and gratuity.
Yes, ma'am.
Now, state is not ready to do that.
No, Lordship. Because of the nature of his appointment was ad hoc. And there's no.
It doesn't matter. You see, this now the question basically, if he serves in that thing, you may say that he was non-permanent, his appointment was not like regularized. But then I think there is a recent decision by Apex Court that the pensionary benefit should be extended to the person who serves, who completes the qualifying period of service.
Yeah, Lordship, there was trial was held and he was found guilty in the DP.
No, we can understand that, but then you see, like
Lordship, there will be a distinction between found guilty and whether, what I understand, Lordship, service benefit, ad hoc or regular, in a normal course, whether they right for those flows or not, Supreme Court has addressed that issue, Lordship. But here in this case, it is not question of he is entitled to a right. His case was he was terminated from service on a departmental inquiry.
We can understand that. But then taking into consideration those aspects, this court has held that you see, like the question of putting back this petitioner back to service
on 4th March, Lordship,
does not arise.
And so, and Lordship,
and then remanding of the matter also will not serve any fruitful purpose. Now, that is where, on that basis, just to give quietus, the court has suggested.
Right, Lordship.
Now, if you are saying that just because his status held by him during his service career is basically an obstacle for you to extend that benefit, then that is not a legal obstacle, cannot be a legal obstacle.
Lordship. That's one of the added grounds. When the court held the Lordship, it relied on a Supreme Court judgment. And that judgment itself is distinguishable by another judgment. And we had argued at length on that, Lordship. And while hearing at length that how the ratio of the cases can be distinguished, then the court was of the opinion, can it be considered? Lordship, we tried to convince the department. Also, department said it has got a far-reaching effect because there are so many ad hoc, there are so many departmental proceedings. So it would be very difficult to consider in the light of any legislation addressing that issue. And especially in a case like this, Lordship, where the case of jailbreak and detailed inquiry was.
So you are not ready to go by the suggestion made by the court due to certain difficulties on the court.
Yes, Lordship. So we would like to argue on merit, and eventually, Lordship, on merit, whatever this court holds, that the government will abide to, Lordship. Yes. If we can sustain the argument that.
Okay.
But the other aspect, if we go by what my learned senior has said, my lord, the order at page, the order of 4/3, my lord, would also suggest, my lord, because it's an admitted position that the subsistence allowance was never paid to me. If that be the case, my lord, the entire disciplinary proceeding, my lord, stands vitiated. That is what the particular judgment says. So nothing remains for argument.
Judgment is there with you?
Well, it's a part of order dated 4-3, my lord.
That is okay, but then do you have that
My
judgment?
lord, we do not have that copy.
That was an order passed at the interlocutory stage, but then
Yes.
now we are at the final stage. So
Yes.
we may have to see it
Yes.
again.
Long time back, Lordship. We'll have to argue at length, Lordship.
My lord, we can place this judgment. You know, I mean, today, my lord, I
if
did
you,
not
if you
bring.
want to take benefit of the judgment,
Of course, my lord, of course.
see, because the suggestion made by this court has not been accepted by this.
Accepted, my lord.
So we cannot compel them to do that, isn't it?
Absolutely, absolutely.
Now your next limb of argument is that by virtue of this judgment, where this admitted case that no substitutes allows paid, then entire proceeding vitiates.
Vitiates.
And Lordship, we have exactly distinguished by another Supreme Court judgment that says.
First, let him see. See, but then, you see, that was an observation made at the interlocutory stage.
Yes.
So if you want us basically still to go ahead with that proposition, then you have to show us the judgment. You have to see.
My lord, I'll place the judgment on, my lord, maybe on the next date, my lord, I'll place the judgment and we'll do the final hearing on.
Yes.
Lordship can consider the entire matter.
Because Mr. Khan says that there is a.
You know, that is why, my lord, we have been trying to get that judgment from the office, my lord, of my learned senior. We did not get it, my lord.
I'll tell look into it.
This, if the judgment is given to us,
He is
my
not
lord,
supposed to provide you the weapons which he will be using. Isn't it?
when in court, my lord, everything has to be fair and square.
Now it has become common for courts to order, you see, like the parties to exchange the citations or authorities which they seek to rely. It was not the practice actually.
Absolutely.
The law says that the pleadings only has to be exchanged.
Yes. But over the years, my lord, the
see,
practice has evolved to a.
The weapons which the parties will use at war, they are not supposed to say disclose it.
And especially if it's a loaded weapon.
But then now it has become a practice now. Basically, probably it helps the court also. Because
Absolutely, Lordship. The purpose is to help the court. When in both the parties also.
So what is to be done here then?
My lord, may have it on some other date, my lord, subject to your
Lordship
lordship
can fix it for
convenience.
hearing in a convenient date when
It's
the court.
already hearing. It is in the
Yes,
hearing.
yes,
column.
it is
hearing
fixed for hearing only.
Next week, no possible. Next week.
After 2 weeks, normally.
I'll place this judgment also, my lord, on that.
There appears to be some judgment, copies of judgment here. This is an admitted position that substitution allowance was not paid.
Not He's still holding the court. Your client. There's an interim order of hearing.
No, sir. He left already.
तब ठीक.
Yes, there appears to be some copies of the decisions. Anyway, we'll see it on the next day.
Lordship, after 2 weeks, we'll try to address the issue.
Okay, on prayer made by the parties. This matter. Okay, I'll just sing on the prayer of the made by parties.
Lordship, yes.
13.
But this matter, my lord, we were directed to file a copies of the earlier writ petition, my lord.
You are not supposed to file it. You are supposed to place it at the
Place
time
it,
of
my
hearing.
lord. We have got the copies, my lord.
You do not know in what context we asked for it. The court has forgotten.
This is the main copy.
Yes.
The prayer,
Page 8. Nothing much, Lordship.
prayer, my lord, was for restoration of the And the affidavit which the state had filed, the same contention which they now seek to take, my lord, before your lordship, the same contention was raised at that point of time also, in the earlier writ. My lord, by overall considering all the contentions raised by the state as well as the petitioner, my lord, that judgment came to be passed, whereby, my lord, they were directed to find out if my grandfather was at all allotted with the plot of land or not. And if yes, if the answer is in affirmative, my lord, then the follow-up action is to be taken. Now they agree to the fact, my lord, that the plot of land was allotted to me. My lord, insofar as the second part of the direction is concerned, my lord, they are not willing to follow that. And they come up with the same plea that, my lord.
Where is this? Where are those things? Directions and all this?
Direction also you will find at page 42 is the judgment. Sorry, page 34. One of the relevant paragraph you also will find at page 38 and paragraph 8. Page 38, paragraph 8. Now, in my humble and respectful submission, my lord, the state are barred by the principle of constructive res judicata, my lord, by taking that same plea again, which has already been dealt with and considered elaborately by this honorable court on an earlier round of litigation. And having considered those contention, my lord, this judgment came to be passed. And my lord, the doctrine of sub silentio, my lord, will apply very squarely in this case, because that contention which they had raised earlier has been considered already. Therefore, the only action that was required of them to take was to find out, my lord, by conducting the proper inquiry as to whether that land was allotted to me, my grandfather, or not.
How do you know the contention which was raised in that case? The other earlier.
Well, I've seen the affidavit, my lord. I've seen the affidavit filed by them in the earlier round. They come up with the same contention, my lord, that it was never possessed.
Is that a plea you have raised in your writ petition, in present writ petition?
No, my lord, here we are in a different footing. We are not, because, my lord, that aspect is already done and dusted. The plea that the contention or the grievance that I'm with before your lordship in this present writ petition is, my lord, in spite of that order, whereby they were directed to find out, my lord, if the land was allotted to me, to which they give their finding in affirmative, the second part of the direction they did not comply. And on top of it, my lord, go to a further extent.
Let us just see what are the directions.
Directions, my lord, will find at page 38, paragraph 8.
Yes.
Lordship has got it.
See, this is a very matter hinges on a very short campus. You see, like if you see these direction parts, the court says that it appears that the plot was allotted to the petitioner.
Yes, Lord.
It appears that it was allotted time. Okay. Now, in such a circumstance, the state government, without following the due process, cannot allot the plot number so to another person.
Right.
Now, we do not know what is the due process. You have to please us what is the due process. Therefore, the respondent wanted to conduct an inquiry to find out if the said plot so was allotted to the petitioner grandfather. Now, on the first part, court says that it appears it was allotted, but then second part, court says that an inquiry should be held to see whether it was allotted or not. And if allotted, necessary follow action should be taken at once. Now it is not their case that it was not allotted. They may say that that allotment was not acted upon. They have never taken over. Okay. But then so far as this order is concerned, once it is allotted, then the due process of law has to be followed.
Follow-up action.
Now what is the due process of law?
My lord, here the
Inquiry only for the purpose of finding whether it was allotted to know. If we are to, you see, remain within the ambit of the order passed by this court. Inquiry was directed only for the purpose of directed inquiry to find out if the said plot of land so and so was allotted to the petitioner grandfather. So that is the scope of inquiry. Nothing beyond that.
yeah.
Okay. So once the inquiry closes by giving finding, it was allotted or not allotted.
Yeah, the finding is it was allotted.
It was allotted. So thereafter, what should be taken up, that is not a part of the inquiry.
No, my lord.
Isn't it? Now, once a finding comes that it was allotted to you, now what is the due process which required to be followed in this case? What as per the order of the...
My lord, in my humble and respectful submission, my lord, the only follow-up action would be to repossess me into possession of the said plot of land. Because, my lord, this judgment, my lord, is in two parts. My lord, the judgment is in two parts. One, my lord, to find out if the allotment was ever made in favor of my grandfather or not. If the finding in respect of point number 1 is in negative, the second part will never come.
What is your cause of action in this case?
Well, the cause of action was the original allotment to my grandfather, my lord.
See,
in this writ petition, it was the inquiry, my lord.
Inquiry is in your favor, it says it was allotted to you.
My lord, the second part of the inquiry is not in my favor.
What does it say?
No, lordship. Inquiry is not in favor.
Well, the second part...
Inquiry is clearly against him.
No, second part, my lord.
Lordship will see page 44, clause 4 and 5. Part of the inquiry.
Page 45, my lord.
Yes.
The allotment in their favor, matter ends.
Paragraph, page 44 onward.
Yes.
My lord, I'll take your lordship to para 5 onwards.
Para 4, lordship, can you have it para 4?
Para 4.
Yes.
The then additional secretary to the government of Assam, RNR Department, Relief and Rehabilitation Department, white letter so and so, stated very clearly that the allottee is to sign the acceptance form and return the same to the office immediately. If no acceptance is received within 30 days from the date of issue of the letter of allotment, the same will be treated as cancelled. White annexure dated so and so, the age of the petitioner as on the date of deposition of the inquiry officer stated to be 46 years, meaning that he was born during the year 1968 or so, which is 10 years more or less after the issue of the above letter during the year 1958-59. Again, White notice dated so and so, it was indicated that Mahendra Kumar, the allottee of plot number so and so, was not interested to claim the plot and never attended the office of Executive Engineer RRR Division, and hence the petitioner could support his claim by enclosing only copy of already attested of the letter dated so and so as annexure so and so, and no other documentary proof evidence could be enclosed. The government of Meghalaya white letter dated so and so at annexure so and so dated so and so had issued necessary instruction on matters relating to registration of cases of so and so. This is not relevant, Malak. The father of the claimant so and so was a registered refugee, yet no allocation of plot of land at so and so was made in favor but to his grandfather, Malak, which created doubt. The plot number so and so remains vacant for a period of more than 46 years when the claimant claims of his inherited the property without any documentary evidence. The government, after following due procedure of the concerned issue, had accordingly instructed the Deputy Commissioner Shillong
The
to take
inquiry is
over.
against you.
Absolutely.
Malak,
It doesn't say so. You
no,
say
in
that
one
you say
part,
that,
Malak, they say that it was, but they admit to the fact that the land was allotted to my grandfather. My lord, so far as the second part of the direction is concerned, my lord, they negate by this inquiry report.
See, you may say that you are selected for allotment.
No, my lord, the allotment order will show, my lord.
Paragraph 4 makes it clear that
That
once...
this is a perverse finding, my lord. May kindly see at page 18, my lord, annexure 2.
What is that?
This is the allotment order, my lord. My name's figure at serial number 15. My grandfather.
Then what was the need of passing of that earlier order by the High Court? If this document is supposed to hold the field, then the enquiry becomes useless.
No, my lord, because they were seeking to, my lord, hand over the land to some other third individual.
You are shifting somewhere. Just we are asking that question that in the earlier round of litigation, when this High Court passed an order directing for holding of inquiry to find out whether the plot of land was allotted to you or not, this document which you are referring just now, it was in existence.
Right.
Yes.
My lord, because
my
my lord,
that, when it is ordered that inquiry should be held,
because
that
they were
means that
disputing
document
this
was
aspect,
not
my lord.
treated as a conclusive evidence of allotment.
Maybe, my lord, at that point of time.
Not maybe. See,
my lord,
we should basically accept the things which we can evaluate, isn't it?
my lord, in that context, my lord, this honorable court on an earlier round was pleased to direct the state government to find out if this allotment was at all made in favor of my grandfather or not. They do not deny this fact.
Allotment inquiry was that. That
Yes.
is what.
Yes. They do not deny this fact. Now, my lord, everything having been considered, my lord, can they go beyond what is directed in that particular judgment?
They have not gone beyond.
They've gone beyond, my lord. They admit to the fact that their land was allotted to me, my grandfather.
See,
whereas in the follow-up action, my lord, like I said, my lord, earlier, the judgment of this honorable court on an earlier round was on two parts. If I fail in the first part itself, the question of second part, my lord, the following will not arise at all.
So that is what is exactly the case here, because you have failed in the first part.
No, my lord, they admit to the fact.
Where is that? We do not see it in
My
the
lord, may
inquiry.
see. My lord, may kindly see the same inquiry report. Paragraph 7, my lord, of page 44.
Yes.
It says the father of the claimant was registered refugee, yet no allocation of plot of land at so-and-so was made in his favor, but to his grandfather. So they admit to the fact that it was issued to, the entire case revolves around my grandfather.
Which created out? You have you are stopping after it. Finish the sentence. Finish reading the sentence.
No, there is the question of doubt, my lord.
See, can we sit like an appellate court and you see like
No, their doubt has to be based on something concrete.
See, that is what the thing
Well,
is. That
merely just writing that it creates a doubt, my lord. I especially, my lord, from a department like the government department, my lord, it just right creates a doubt. Creates a doubt on the basis of what?
Basis is that father of claimant Mohitlal Das was registered refugee, but then allocation was made in favor of his grandfather. Now
Yes.
that becomes because as per the scheme, the allotment should have been made to the registered refugee, isn't it?
No, my lord, may kindly appreciate at the relevant point of time, my father was very small. When I had, my lord, in an exodus when I came to India, my lord, or for that matter in Shillong, my lord, I was very small. The land could not, my father was very small. The land could not have been allocated in the name of my father. It would obviously be in the name of my grandfather, which they admit.
But then your grandfather's name is nowhere reflected as the list of the refugee.
No, my lord, here
That is what
at page 18, my lord, my grandfather's name is clearly mentioned.
See, if you are a minor, if you are minor means if Mohitlal Dev was a minor, name would be registered along with some major, isn't it?
No,
Or as a
my
minor.
father's name is there, my lord.
See,
Now, if they have prescribed
father's
this,
name, your father's name is there.
yes,
That is
no,
what-
not my father's name. My grandfather's, Mohitlal Dev's father's name is there. Mohindra Kumar Dev.
Now, how do you know it? How do we know it? It is there or not there?
My lord, at page 18.
Page 18.
Yes.
Yes, what is that?
Serial number 15, my lord.
Yes. That is your grandfather.
Yes. These are names of allottees.
Okay. What is the age of your father at that point of time? In 1959? What is your age now?
My lord, I must be around 60, my lord, above 60, my lord.
No, there is no disclosure of your age anywhere.
Yeah.
Anyway, this is all right. Probably you are correct what you say. You see, like if it is, if his name appears in the registered refugee non-allocation, could not have, you see, like seen from, you see, like as a non-allocation could not have taken as a doubt. Why? You see, like maybe if one person of a family is allotted, why should we reallocate to someone?
Absolutely.
So this appears to be this finding recorded paragraph 7 is basically appears to be without any basis.
Absolutely, my lord.
Yes. And your claim basically is with regard to the plot which was allotted to Mahendra Kumar Roy,
Right.
isn't it?
Right, my lord.
In the present case.
Within 30 days, they will execute.
Yes, Mr. Khan, what is the basis on what basis? What is the basis of that finding at paragraph 7, page 44 at the bottom?
Lordship, will kindly come to page 19 again, please. 18. Type copy is a 19.
Yes.
First paragraph, Lordship.
Yes.
24 November 1959. This is the selection list, Lordship. There are two parts involved. So first paragraph is the list is selection. Compliance of first paragraph is very important. The allottees of Umpling Colony whose names are noted below are requested to approach the executive engineer Shillong and get the plots demarcated by boundary pillars at their own cost as pointed out by the field staff. They are further requested to receive the certificate of possession.
We have gone through, Mr. Khan. Sorry to interrupt in the middle.
No, Lordship, kindly
You see your own finding here at page.
No, I'll come to this, Lordship. Kindly, because this has got necessary connection with para 4 and then 7.
Yes, please.
So first thing, Lordship, is this the certificate of possession from SDA Land Settlement Shillong after signing the necessary agreement at the office. Lordship, in first round and second round, it's an admitted case. There is no certificate of possession either pleaded by Mohinder Lal De, the grandfather.
We are not going to that question. We are just confining ourselves to the observation made in the earlier round of litigation by the High Court.
Lordship, I'm coming to that, Lordship.
Why you are going to that thing, certificate of possession?
Because that has got direct connection with para 4. Para 4.
See, the earlier round of the High Court, earlier order of the High Court, in the earlier round of litigation, we say
appears to have been allotted.
You hold an enquiry to see whether it was allotted or not. See whether that allotment was honored or not honored, that was not the thing there.
Lordship, the allotment had two parts. Lordship, allow me to just satisfy your court. Allotment had two parts. The first part is this page 19 is the selection list. State is admitting, we are not denying it. So far the allotment under the scheme is concerned, had state been denying, then your Lordship, state doesn't have a case. But this is the selection list, you need to comply with the certificate of possession after inquiry. Now, only if that is done, that is why Lordship, when in the earlier round, court said it appears that the plot number 267 has been done and they follow the procedures. So far appear is concerned, that's why I was reading out the first part. Certificate of possession is very important. Now, Lordship, how is this connected with para 4? Then I'll come to it. Now, Lordship will come to the inquiry at para 4. Page 44.
Yes.
Then, now we are concerned with so Lordship, we are concerned with Mohinder Kumar De only, the grandfather. Whether his right got crystallized, whether he had fulfilled the condition, whether as per the scheme, the select list culminated into allotment and occupation. That is the requirement of law.
Please proceed, please proceed.
So we'll come to 7 only when Mohinder Kumar De fulfills the requirement of para 4 or not. The then Additional Secretary to Government of Assam, Lordship, Relief and Rehabilitation Department, White's letter 8/9/1858 stated very clearly that the allottee in the selection list is to be signed the acceptance form. I read out, Lordship, page 19, and return the same to the office immediately. This is very important, Lordship. If no acceptance is received within 30 days from the date of issuing of the letter of allotment, date of allotment of letter is 24th November 1959, page 19. The same will be treated as cancelled. Lordship, this is very, very important word. So far, selection list, name of allottee, becoming the allotment, the process to be completed. On the expiry of 30 days, his rights stood extinguished. Annexure 8, the age of the petitioner as on date is of his deposition, so and so years, meaning therefore that he was born during. So this is not relevant for the purpose of Lordship. Now Lordship will come to let me answer para 7. That the father of claimant, Mohit Lal De, was registered refugee, yet no allocation of plot of land at RR Colony Ranger. Mohit Lal De, Lordship, is nowhere in the picture at this stage in 24th November 1959. Who is in the picture is Mohinder Kumar De. If Mohinder Kumar De rights get crystallized by complying within 30 days of certificate.
That's all right, but then what does it? This is your own finding.
Then Shillong was made in his favor, in his favor, but to his grandfather.
Which created out? So what is meant by it?
Lordship, grandfather is page 19, serial number 15.
Yes, all right, but then which created out? What does it mean? Do you want to say just because no allotment was laid to Mohit Lal De, matter becomes doubtful?
Lordship, I don't want to go to the mental process of the inquiry officer. Let's be neither here nor there. Let me admit very frankly, neither it gives it any clarity, neither it gives any right to petitioner, neither it favors the state. Basically, what the inquiry officer is saying is that Mohit Lal De's name doesn't appear in the list. So it's creating a doubt.
So that means two things is very much clear. One is that they have never come forward to sign the acceptance and to take the delivery of possession.
The grandfather, Lordship,
That is what.
Mohinder Kumar.
That is what. So once it is not acted upon, there is no question of finalization of the allotment. That is a kind of, you say, like preliminary allotment.
And 30 days, it stands cancelled. The word cancel is very important.
The second part is that it has remained vacant. So that is
and para 7 is very clear. Lordship. Para 7, the last part. The plot number 267 has remained vacant for the period of more than 46 years.
So that is good enough to show that they were never in possession.
Absolutely correct, Lordship. No, Lordship. Lordship has raised a very important issue. I am very grateful, Lordship, that after the first round of litigation, direction for inquiry was there. And the subject matter for this writ court would be whether court will sit as a court of appeal on the process of inquiry. Whether the inquiry process is vitiated or not. on the face reading of it. Para 4 and para 7, Your Lordship, because para 4 and para 5 is very important. Para 7, it doesn't help anybody. It doesn't help even the state. The inquiry officer is not even helping the state. We are not taking a benefit of it. He himself is not in a doubt. Perhaps he was not clear. So para 4
is good enough.
And Your Lordship, para 5. Lordship, kindly read. Allow me to just read para 5 to further clarify.
Yes.
Again, what office letter 2411 to 1959. So the inquiry officer finds the letter page 19 here. He has quoted. It was indicated that Mahinder Kumar De, no, Mahinder Kumar De is 15. Allottee of plot number 67 so was not interested to claim the plot and never attended the office of executive engineer R. Kanashalong, and hence the petitioner could not support his claim by enclosing a copy already attached of the letter so and so, and no other documentary proof evidence could enclose provided.
Means what? What is
Lordship,
that?
the moment you read para 5 clearly, 7 becomes automatically clear. When you're talking about petitioner, you're talking about Mohit Lal De. So Mohit Lal De could not bring any documents to show his father had attended the office. His father, neither he could produce any document. In other words, 24th November 1959 required a certificate. During inquiry, the petitioner could not produce any documents to show that his grandfather had certificate of possession, had attended the office, nothing. So the onus was on the petitioner to discharge the burden before inquiry officer as to how his grandfather's right, Mohinder Lal's right, crystallized into allotment. He still remained an allottee. In other words, in the select list. On the expiry of 30 days of the scheme, Lordship, 30 days, we are in 2025. So it lies, Lordship will kindly recollect, my only submission was they don't have an enforceable right. Because the legal right never crystallized. And now this has been, on facts, the inquiry officer has discussed on 4, 5, and now 7 will become very clear also. So there is nothing perverse finding of the inquiry officer. The issue of certificate has remained proved. The issue of not coming to office remained proved. Mohit Lal De could not produce any documents to show his grandfather complied with the requirement. And the allotment process was complete. And Lordship is aware, once the scheme says 30 days, it stands cancelled, the whole right got extinguished. So now, in that context, Lordship, if a Lordship reads the first round of direction by the Honourable Court, it appears that 267 was allotted to so and so. No, we are not denying it, Lordship. State cannot deny it. So for the select list and the allotment is concerned for the report. What is important is the process could not be complete and the rights could not be crystallized in terms of grandfather Mohit Lal De becoming an from allottee to becoming a allotment under the scheme.
You filed an affidavit, Mr.
Lordship, yes. That is our specific plea only.
So you have taken that plea.
That is the only plea, Lordship. Now, Lordship, what has fallen from your Lordship is, and we are grateful to Lordship, is that after the first direction, the only limited scope is whether there is a perverse finding in the inquiry. So we are only in the issue of whether there is a perverse finding in the inquiry. Para 4, 5, 7 clearly shows that the petitioner could not.
See, earlier round of High Court order is binding on both the parties. Because
Absolutely.
it does not challenge anyone.
Absolutely, Lordship.
Now, then the matter culminates with the finding recorded in the inquiry.
Yes, that is the only. We have got a
Now,
limited
only
scope.
Inquiry, finding in the inquiry can be interfered if it is shown that
There is a perverse finding. No, not based on documents.
There is a perverse finding and it was done by violation of
Natural
principle of
justice. So many things.
That is what the scope is.
Participated.
Nothing more than that. Now, it is not their case that the finding has been recorded without any materials on record.
Absolutely correct. Lordship has seen para 4, 5 and 7. They have not discussed it. No documents put there.
they do not have any material to show
Yes.
that the possession was taken over and this acceptance was signed in terms of the
Absolutely.
allocation.
Absolutely, Lordship. Regular will be a great
So
thing.
that means there
once,
cannot
once,
remain anything.
Lordship, even my limited submission would be, Lordship, if the state can satisfy that the inquiry does not suffer from perversity of finding, no lack of hearing, and based on documentary support, the most important document was not present, and that document was the certificate of possession. We are not asking Mohinder Lal De. The petitioner herein ought to have produced. And there is a clear finding in para 5 that no documentary proof could be produced by petitioner. In other words, that after the expiry of 30 days, nothing survived. So basically, there is no perversity in the inquiry report, and court will help pursuant to the direction of the court. There is no infirmity in the inquiry report, and hence the writ petition is dismissed. The matter is as simple as
This
that.
plot, is it a vacant thing or there
It
is
is a
structure?
vacant land.
There
It
is
was a
structure
vacant
standing there.
It was a vacant land.
There is a structure, my lord. Assam
There's a-
type
there's a
structure
permanent
is there.
structure.
Assam type structure is
Who built
there. Admittedly, it was made by my grandfather, my lord.
I'm slightly surprised, Your Lordship, if he makes such a very strong statement.
Anywhere in the record to show that you have
Nothing.
Yes, my
directed
lord.
in structure.
There is, my lord.
You have given a statement before inquiry officer. Did you?
No, my lord, the statement was never taken.
Your statement
In
was
fact,
never
my lord, the inquiry officer, the order was passed by this Honorable Court in the year 2013. He relies on a statement made by somebody from the same locality in the year 2009 to negate my right.
Anyway, just tell us whether your statement was recorded at the inquiry.
No, my lord.
So then, which way you were afforded a chance to take part in the
No, that is why, my lord, we have been all along, we have been saying that no notices were ever issued to me.
in the inquiry?
Yes.
Is it?
My lord, may kindly see.
Lordship, you kindly see page 43. Everything is page 43. Finding and observation. Very surprisingly, very strong statement. Your Lordship. On the face of it, if my ex
My lord, may kindly see where.
Shri Minal Kumta De deposed before an unassigned. Lordship is such a
you are saying something which is
such a wrong
useless.
statement.
You see, if you say this, court will detect it. It is not that court will pass order blindly. And the other side is there to point it out.
And that too, Lordship, we are before a very competent court, Your Lordship. It's very dangerous to make a wrong statement. We'll be hold very heavily, Lordship. And this, Lordship, can you appreciate? State has got nothing personal, Lordship. Why will state
my
not
lord.
give them chance of hearing?
My lord, may kindly appreciate one thing. Here, my lord, whatever my learned senior has placed, my lord, will that have any material bearing insofar as the consideration of this writ petition is concerned? My lord, because those, whatever contention he has raised now, like I submitted and I reiterate, my lord, those submissions, contentions was already considered by the Honorable Court in the earlier round of litigation, where the court had at a threadbare consideration, my lord,
There is a
whether I
requirement-
have.
See, there is a requirement of reasserting it. For the purpose of determining whether there is any finding recorded in the inquiry without any basis of record.
No, that is why.
You see, earlier round of litigation, as what this court gets from perusal of the order, is nothing. Court has not gone into
Anything.
the merits
My lord,
to determine
like I
the
said,
fact.
my lord, in the affidavit, I've gone through their affidavit. The same plea were taken by
That
them
is all
earlier
right.
also.
That is all right. But then, if this were not adjudicated upon the doctrine of the application of res judicata or construction of res judicata, will never come.
No, not
No, my lord, the
It is
doctrine
not
of
a
sub
there-
silentio will come.
See, Mr. A contention is raised which is rejected. There may be, you may say, but then here is nothing.
My lord, here,
early-
if a particular party, my lord, raised certain contentions, and the court after having considered those contentions, if passes an order, my lord, even if it does not reflect in the order, my lord, it is deemed that it has been considered and rejected.
Are you
That is
treating
what
it
the
as a-
doctrine of
see,
sub
Are you
silentio.
treating it as a civil court? We are trying a suit.
No, absolutely not.
No,
We are exercising jurisdiction. We are exercising power of
However,
judicial-
finding
judicial
of inquiry report. Lordship, the only limited issue would be whether there is any perverse
my lord,
finding.
the very fact, my lord, the inquiry officer relied on a statement made by somebody in the year 2009
What is the statement and what kind of reliance was placed in that statement?
Neither affects them nor helps them.
kindly see.
That is,
But
Lordship,
it goes against me.
Page 43,
It goes
Lordship.
against me, my lord.
Let us see whether any finding is recorded.
Nothing.
in that.
Lordship, will kindly see page
Goes against me,
43.
my lord.
Yes.
But page 43, para 3, my lord.
Yes.
Shri N. Bhattacharya, President so-and-so,
Page
has
40,
page 43,
Yes.
para 3.
Para 2 is the para 3.
Para 3.
Para
Page
three.
Oh, it's
43.
on the top.
On the top.
Because down below is para 2. That is why.
Right.
Yes.
Now, Shri so-and-so had made in his statement on 23/9/2009.
Yes.
Now, my lord, this goes to show what
Just-
kind of an inquiry
yes,
it
yes,
was. Stating that he's a lessee of plot number 12 and staying at so-and-so since 1963. At that point of time, there were only a wooden structure with a tin proof. This goes to establish, my lord, my grandfather had actually constructed. Proof standing at plot number 267, and do not recall if anyone was living in this plot in those days. He also stated that NGO and private workshop were established inside the plot without authority, and hence stated that he do not think if anyone claimed the land for the purpose of residence. Now, my lord, this statement was taken by the inquiry officer
That is
to
okay, but
prove
the
that I was
structure
not in
seems to be constructed by this NGO and private person, unauthorized.
No, my lord, the tin roof was prior to the land being used by the so-called NGO. I do not know how this statement has come. And I was never given an opportunity to rebut this.
Lordship, how does it address the issue of certificate? 30 days
No,
period?
but certificate and all, my lord, this were already considered by the court earlier round of litigation. And in that premise, my lord, this order came to be passed. You first check if the allotment was at all made or not. Because all this contention, the certificate was not given to me, I did not take possession of the land, so on and so forth, was already raised at the earlier round of litigation. Having considered all those arguments, my lord, that judgment came to be passed, where the Honorable Court, my lord, was of the opinion that you first find out whether the allotment was made or not.
Lordship, my friend has been repeating time and again. Let us just confine to page 43, para 3. Let us address this first. Lordship, assuming, let me just finish.
See, like there is no use of you say like talking simultaneously.
So, Lordship, since we are addressing para 3, let me just address this issue.
Well, whether I took possession or not.
Sukhdev, 1 minute. Let me just address the issue.
Yes.
Page 43, para 3, Lordship. Yes. Now, this is a letter of 23/9/2009. Assuming that this letter was prior to the order and the inquiry officer is considered. Now, the relevant part would be, it's only about wooden structure, nobody in possession and NGO. For the sake of argument, Lordship, remotely, let us come down to findings and observation.
Yes.
Number 1, he has not referred to this letter. Number 2, he is still not referred to this letter. Number 3, no reference to this letter.
Letter or statement?
Number 4, number 5, number 6.
Letter means or statement. You are saying it's a statement.
The statement, Your Lordship.
Not letter.
Letter or statement, Your Lordship. So neither is related in 2, 3, 4, 5, 6, 7.
7 there is.
7. So what perversity has the inquiry officer done? Even it was a kind of a submission, but there is no finding, and neither is here nor there.
Well, that
Neither it
statement
helps the
was
state.
relied on to come to a finding at page paragraph 7.
Lordship, please allow me to address this issue first, then he can reply. At least allow me. Now, whose cause has been either substantiated or extinguished by this para 3? Nobody's. What is the perversity? Perversity issue would rise only when the statement of this has direct bearing. And what would have been the direct bearing of this statement, Lordship? The issue of certification.
See, Mr. Khan, what you say appears to be not correct because this finding has been recorded on the basis of this statement. Just see. Come to page 43.
Page?
Come to page 43.
43.
Finding and observations. See, Minal Kanti, they deposed before this underground so and so.
Correct, Lordship.
Thereafter, proceed and see.
Yes.
See, N. Bhattacharya gave a statement in writing before the district collector.
Correct, Lordship, yes. Absolutely. Lordship, finding and observation.
Just a minute.
Yes.
Now, the question, the N. Bhattacharya could not have given a statement in 2009 because the inquiry started thereafter. Okay, so his statement was not in relation to this inquiry. This is first thing. Now just read this, the next paragraph from the depositions.
from the deposition of petitioner, power attorney holder, and statement of so and so,
Yes,
and also
this
from
president
inquiry, in fact, and position of so and so.
Yes. So that was taken into consideration.
Observe, Lordship.
So that is something. That is something.
There is something, Lordship, absolutely correct.
So,
but Lordship, where
We
is
will
the
remand it back then in such a case. There is no question. Once it is shown, because this is what it is.
but
It is
Lordship,
very much clear. this
where is
observation has
where is
been
the finding on the wooden structure?
All right, you see what it would have been. See what law requires is that if any statement is taken into consideration, and the petitioner is not given chance to rebut it, that is denial of fair opportunity.
Lordship, he was present there. He could have easily. And this is not an oral
He was not
statement.
present in 2009. That is a problem.
Lordship, this is not an oral statement. Lordship, kindly see, this is a statement by Annexure 3.
See, this is what Envertaji gave his statement in writing before the collector Iskasi district in 23rd September 2009.
2009.
Now, if this statement was to be relied upon, he should have been afforded an opportunity.
Lordship, if
Now, you said this court was all along convinced by your submission that it was not taken into consideration for recording observation, but that it is very clear.
But Lordship, if you stretch that argument further, because as I said, it was not an oral submission or any documents. These are documentary evidence. Lordship, then all the documents of 1954, if I go strictly by court's order, Lordship, none of the documents of 1959 can be relied on.
Mr. Khan, we are not going to say what bearing it would have had in merits of the decision. That is not our duty to say. We are only concerned with the manner adopted in the inquiry. That is what, nothing else.
But Lordship, where is the prejudice? Where is the perversity? Lordship, kindly let us address the issue. Let him will reply, let him address the prejudice part.
Mr. Khan, the thing is that...
and where is the perversity and where is the prejudice?
See, just a minute. If any statement is relied upon, that is good enough. That is what he says from the deposition by the petition and the power of attorney holder, and the statement by the President RR Colony. So that is enough. He was the President RR Colony as reflected on the top of the page 43.
No, Lordship, but Lordship, if you see the subsequent paragraph, there are all documents of 1954, 1959.
You can understand. Then you are trying to say that if he balance the merits, then he might not have a case.
No, but Lordship, let him satisfy.
You may be correct also.
Lordship, let him first satisfy what is the perversity. He has to argue the onus is on him, and then the prejudice.
See,
then only the court will.
The entire inquiry has gone against me. That is the prejudice.
See.
Lordship, for a moment, kindly appreciate
the right under 300A.
The thrust of the inquiry is para 4 and para 5. If that is affected because of perversity, then Lordship will set the clock back. State has got no interest in Lordship. And we are being very impersonal.
We can understand. We are basically concerned with the norms to be adopted in an inquiry. And the kind of jurisdiction we exercise in 226 in relation to such kind of inquiry.
Absolutely.
We are not going to say anything on merits. What we understand, that statement of certain individual was taken into consideration. That is apparent from the recording or the observation made here.
But Lordship, then Lordship is correct. So long I am Lordship, I am with this court, Lordship. But then Lordship is very clear. The settled position in service president Lordship, he has to say how it has caused prejudice, number one, and how it is perverse. If there is no finding of perversity and he has not been caused prejudice, he will be caused prejudice only when the issue of his grandfather's certificate has been affected. That is the thrust. Now, if that has not been shaken...
You are tracking basically...
On para 4 and 5.
See, like impress the court about the merits of the matter.
No, not merit.
We are not at all concerned.
Lordship, we are not into the merit.
You may be correct in saying that yes, there was no allotment order. Okay. But then that was a situation which was there even before the inquiry was ordered. Once the court has ordered an inquiry, then an inquiry has to be done in the manner it should be.
Lordship, kindly let him satisfy what was the manner it should be done and where it has deviated. See, is this his case?
There are certain principles for which we may not call for any assistance. We know that if something is relied upon and the other side is not given an opportunity.
Lordship, Lordship, he was present in person. Where is his objection to this letter of 23/9/2009, Lordship? Kindly. Once his objection is not there, then how can he plead perversity and prejudice, Lordship?
See, this statement was not recorded in his presence.
No, he was present. Lordship, kindly see.
2009, he was not present.
No, Lordship, I'm not into 2009. When Minal Kantade was deposed on 6 January 2019, Lordship, when he deposed, Is it his case? Then while deposing, he was never given a statement of this copy.
I was not even aware, my lord, that
Where
he
is
is
his
relying in
pleading?
a statement made on 2019 or 2009.
Lordship will kindly
The
appreciate.
inquiry never says, my lord, the
When
opportunity
he was present, when he was present on 6 January 2014, where is his objection to this statement? Or even after, for the sake of argument, Lordship, even after the inquiry, where is his pleading in the petition that he had objected and inquiry officer never considered? How does he overcome that pleading?
This is not taken as a ground.
No.
Let us see.
Let him satisfy your Lordship. And where is his objection before the inquiry officer?
that, my lord, those opportunity was never granted to me.
Lordship, again he is saying...
Have you taken it a ground in the writ petition?
Yes, my lord.
That he was not given a chance,
Yes.
he objected to. He objected to non-consideration before the inquiry officer. Specifically that sentence, Your Lordship.
What do you say about that
Had he objected before the inquiry officer?
president of our colony?
No, my lord, because this order was never given to me, my lord. That
No,
one, my lord,
inquiry
I have said in the
Inquiry
paragraph
report.
14. Paragraph 14 of my writ petition at page 11. And paragraph 15 also, my lord, where I say, my lord, the notices were ever given to me.
There's a casual reference that statement of Shri Bhattacharya was recorded on 23/9. Inquiry officer relied. My specific query, Lordship, where did he object? During the proceedings or after the proceeding?
Well, there's no question of me objecting, my lord,
There's no prejudice caused to him.
because I was not even aware that the statement.
Evidence of a person, is it a documentary proof? What's the oral evidence?
This was statement on Annexure 3.
It has gone there as oral evidence or as documentary?
Documentary.
So if this is a document,
And Lordship, as per the writ petition, he was aware.
if he sought to be,
Lordship will kindly...
he would not know what statement has been given by some individual before you, because he doesn't know
But Lordship,
all those things.
Lordship, does he mention here from where did he come to know of 23/9/2009? Why he could not object to before the inquiry officers?
Okay, it's all right. Just because he has not raised any objection doesn't mean that it should be taken here.
Lordship, if that objection was raised, we had to rebut. We don't have opportunity to rebut. Neither has he raised it.
Here is my statement was recorded.
Lordship, neither he has raised that. Neither he has raised it before the inquiry officer. Neither he has said that he has come to know only after the inquiry officer judgment. Lordship, kindly appreciate this is a standard law of pleading. State has to respond, Lordship. And had he objected, Lordship will kindly appreciate. Had he objected to the inquiry officer's finding,
In the inquiry, did you file anything in writing?
No, man.
nothing.
Your statement was recorded there. That is
In
what has
fact,
been
my
recorded
lord,
there.
my statement was recorded. Thereafter, my lord, they went on to
Where is your
inquiry.
statement?
I was never called.
Where is your statement? Recorded on 6 January 2014.
Yes, that is very important, Lordship.
Where is that?
But that was never provided to me, my lord. I was only provided
you
with
are
the inquiry.
you are arguing a case without knowing what your statement before.
No, my statement is very much the same one, my lord, which find
How do
mentioned
you
in the
say,
inquiry.
how do we know it? How do we satisfy ourselves to that? Because
My
your
lord, this
statement.
inquiry-
see,
my lord,
one thing, Mr. Khan is correct that yes, this 2000 your statement comes up 2014. Okay, so much after 2009. So let us see what if you have taken any
Yes, Lord.
said anything addressed with
No, my
with
lord,
regard to the statement of.
my lord, at the time of recording my statement, my lord,
Can you produce the record, Mr. Khan?
let them produce the record, my lord.
Okay, Lordship. Yes.
Now let us see. Since
Lordship
you,
is correct.
since
Lordship
you
is
have also raised that whether he has raised before the inquiry officer about that or not, let us see that.
Yes, that is the only issue,
No,
Lordship.
my lord.
Will produce.
Before even my lord, just assuming, my lord, before even I rebut those statements made in the year 2009, I have to be made aware that such a statement is made by somebody in the year 2009. At least that copy has to be provided to me.
Lordship will produce the record.
If that is not provided, how can I rebut those my lord, assertion made by some third individual?
But where is the pleading, Lordship, in the writ petition? Lordship is held.
My lord, this inquiry officer was.
Just a minute, just a minute.
This inquiry
Just a minute.
report was
Just
came
a
to be
minute.
provided. my lord.
Just hold on for a
My
second.
lord, my lord.
Now, the reflection of your statement in the inquiry, it speaks about other submission of other document apart from that order of that 1959. Have you got it? At page
Yes, sir.
42. See the subpara of
Para one.
Yes.
If they records, my lord, that I have submitted all the documents
What documents?
concerning the land.
Now, what
Consent-
are the documents you submitted there?
Now, this was submitted. I have to take instruction, but my lord,
That
they
is the
should be in
problem, Mr.
possession of
Thapa.
all
You
those
do not
documents.
know what is your statement before inquiry. You do not know what are the documents you have submitted.
My lord, but
You are challenging an inquiry.
let them
to-
produce the record, my lord. We
Knowing
can-
very well that we will not go into the merits of the decision.
Absolutely, Lordship. Only the process.
Until and unless you can show there is a perversity or denial of principle of natural justice, we
Yes.
may. Otherwise, there is no question.
My lord, perversity, there is ample perversity in this inquiry report. The very fact, my lord, the inquiry report travels much beyond the direction of this honorable court, my lord, makes
Which
it
way?
perverse.
Which way it travels beyond?
My lord, like I already submitted, my lord, the order was in two parts. Find out if the land was allotted to me. They say yes. Then the necessary
they say
follow-up
no.
action, my
They
lord.
do not say so, yes. They say no.
No, the answer is in affirmative.
No.
They said it was granted to my grandfather.
It was not. You see, like it is not that we should read one sentence as isolated.
No, my lord, then if
Take
that
the
be the case,
probability
my
of
lord,
the finding.
my lord may kindly appreciate, if that be the case, it makes this inquiry report even more perverse. If that be the case, if there is no finding to that effect,
To what effect?
to the effect whether it was allotted to me, my grandfather or
It has
not.
been said in paragraph 4 clearly. What more is needed?
No, paragraph 4 nowhere says, my lord, it was never
Paragraph 4
allotted.
is very much clear.
No,
They
no, my
say-
lord. Paragraph 4 never says.
They say a conditional allotment was made.
Conditional allotment was made, my lord, but they nowhere says
They
that,
have
my lord, it
never
was
turned
never
up.
allotted.
You have never turned up.
Maybe,
accept
my lord, I have not turned up.
Matter ends,
My
you
lord
do
may
not-
kindly,
you do
my lord
not-
may kindly
if that
see the purport.
situation stands correct. Other things are totally irrelevant.
No, my lord may kindly see the purport of the earlier order. The earlier order was confined only to the aspect of whether it was allotted to me or not. Whether it was a conditional allotment, non-conditional allotment was never the purport of the earlier order.
See, allotment, we have to understand in that way. There must be a completion of process. Allotment means final allotment. It is not that the indication to allot. The indication of allotment. It is not that. Okay. Now, if court had passed any order for holding an inquiry to find out whether allotment was made or not, that will definitely refer to final order.
My lord,
So, once that position remains undisturbed, subsequent non-adherence to other aspects
my lord,
may not make out a case for you.
my lord may kindly appreciate. My lord, allotment in my humble and respectful submission would be whether there was an offer to me or not.
Yes.
The offer to me was there. My lord, the fact as has come out in the inquiry report shows that
If you say that, if your submission, then how could you allow that the order passed in the earlier round of litigation to stay without challenging? How could you taken part in this?
No, my lord, because
If
I was.
according to you, if this order is sufficient enough to show or prove that allotment was made to you, then what is the purpose of inquiry?
No, my lord may kindly appreciate. The order was only to the extent of finding whether allotment was made or not. My lord, it is not denied by anybody that it was made. It may be a different aspect that I did not take possession or whatever. But my lord, the fact of the matter remains the allotment was made to me, my lord. It was in the name of my grandfather, which nobody denies. Now the next part of the direction, my lord, the necessary follow-up action. Now, my lord, by any stretch of imagination, my lord, can the purport of that particular judgment passed by the Honorable Court in the earlier round be taken as, my lord, depriving me of my right, having found that the land was allotted to me? The only corollary that will necessarily follow, my lord, if the first part in affirmative is to restore the land in my possession. And that is why, my lord, coupled with the fact that, my lord, the prayer made in the earlier writ petition was very clear.
If your land is in your possession, what is the question of restoring it?
No, my lord, because they were trying to evict me at that point of time and place somebody else in my position.
They were trying, but then they were not successful.
They were not successful because the Honorable Court had intervened by way of an interim order.
So land is in your possession. What is the question of restoration of possession?
No, my lord, may kindly appreciate, they were not granting me lease. They were not granting me lease. I have made an application to that effect. In the earlier round, my lord, there are correspondence from the government side, from the department to the government, asking them whether it can be considered or not. My lord, if I have no bona fide, or if I have no right in the first place, why would government even entertain my application? The fact that my grandfather was allotted with the plot of land, that is why it gives them an opportunity to at least consider my application to that effect. My lord, let them produce the record, my lord. The documents that I have submitted, my lord, would very much be within the
But
document.
then you yourself you do not know what document you have submitted. You yourself you do not know.
My lord,
what
I'll
statement
come
you
on
have made.
instruction what documents we have submitted.
See, this
My
case
lord,
is
this
pending for
inquiry
quite some
report
time.
also was provided to me after I filed a contempt application.
What?
This inquiry report, my lord, was given to me after I filed the contempt application. In fact, they were not even willing to give me this inquiry report. This is the level of, my lord, the level at which the government was hell-bent on throwing me out of
So
the...
they are biased. You want
My
to
lord,
say?
we may take that view also. Because we filed a contempt, we had to file a contempt only to procure the inquiry report.
Mr. Khan, will there be difficulty for you to produce the record?
I don't think so, Lordship. No. Only for the purpose of that, Lordship.
Yes, so you'd like to see what documents you submit.
Absolutely, Lordship is correct.
You do not know there in that document there may be and possession certificate also.
Yes.
Lordship will see our affidavit para 7. We have categorically stated and there is no rebuttal to it. The argument that I have made is absolutely made in a very clear, lucid term in para 7. There is no rejoinder to it. Matter ends there.
There are some flaws also in the inquiry.
He didn't, no, Lordship, not for a moment I'm denying. Lordship, not for a moment I'm
What
denying.
we are just trying to assess is that whether those flaws have prejudiced him.
That is the only limited issue, Lordship. Nothing.
Otherwise, repeatedly remanding back a matter also doesn't serve purpose.
Lordship, for the sake of argument, Lordship, just for a moment, let me play a devil's advocate here. Lordship remands the matter back. Then inquiry officer calls, gives him a notice, and he appears, state appears. He deletes Nava Bhattacharya's statement and affirms everything. How does it change him?
But do not advise them to do it.
No, Lordship, no. I'm saying playing in devil's advocate, for the sake, Lordship decides against it. Matters remanded. I'm an inquiry officer. I take 24 hours, delete the name, and says by mistake there's a court direction. Will that confer him a right? Supposing.
That's all right. We can understand that.
It doesn't make any sense. I understand if it is caused prejudice, remanding back would give him a right. Our prayer in para 7 of the affidavit is very clear regarding page 19, paragraph 1 and clause 4. And this is, Lordship, very important. Lordship has held in Lushai matter even. There is no pleading. Why is he forwarding all this oral argument without pleading? It's an admitted fact. No certificate. Either in first round, second round, now. The moment certificate is not there, 30 days, the rights get extinguished. Lordship, we are talking about 1959.
But then, whatever the situation, the court had directed for holding.
Yes, the court has directed for inquiry. Inquiry has affirmed only that part, Lordship.
Meaning that, in spite of the fact
Yes.
that there was no certificate of possession,
Yes.
court wanted to give him a chance so that if he can establish something in the inquiry.
Exactly, Lordship. That is the only limit. And he couldn't. And he could
for
not.
an impartial inquiry. This inquiry turned out to be a partial one.
Well, we do not know why it is. You are saying partial. Why?
My lord, the way, the manner in which,
my friend is very liberal with the word impartial. Then did he make inquiry
the
officer?
manner in which
party?
the inquiry report was, my lord, the inquiry report has gone. You would see, my lord, 2009 statement is relied on to deprive me of my right under 300A.
I have already submitted, Your Lordship. If the Lordship demands back, how does it change? Imagine we are having an inquiry committee. How did it change?
They will come once you establish your position over the land. Your own.
Everything will, Lordship, State will be very grateful once he can establish that right. Then we'll leave it to the discretion of the court. That right doesn't exist. In law, Lordship,
Those
doesn't
aspects
give
need not
the
be
writ petitioner
gone into
right
in this
for
particular writ
mandamus.
petition, my lord.
So you see, if you talk together, nothing will go ahead.
Well, let them produce the record, my lord. That will perhaps bring more light into the case.
The law is settled, Your Lordship, that burden to discharge always lies with the petitioner. He is failed to discharge his burden as to why he is entitled to
See,
it.
inquiry is held by you, and if you yourself you withhold something.
No, Lordship, no. We will produce.
At the backdrop of the submission that even that inquiry report was provided only after they filed a contempt. So that is where.
Lordship, I don't know. I don't want to reply to a lot of things.
His plea of biasness comes from there.
Lordship, I don't want to submit on that because there was a delay, no doubt about it, delay. But there was a delay for some procedural remedy. But it is not the case that contempt was filed, bias
Contempt
was
was filed. It's a part of the record.
No, but Lordship, the moment he says this, then has he pleaded bias here? Just because he wants to make an oral submission, anything, Lordship, how will a state reply to that?
So that is also is not pleaded there.
Lordship, can you appreciate the restraint that state counsels face? When there is a pleading, we'll reply on the rebuttal. If there is no pleading, to which level will I reply to the court, Lordship? I'm not under instruction to reply anything beyond affidavit. No plea of contempt, no plea of bias, nothing is affected, no plea of prejudice, no plea of perversity. The only thing is that letter. No plea that after inquiry officer gives the finding he is objected to. Nothing.
Just do one thing, produce the record. Let us try to satisfy ourselves.
For courts, Lordship, will be very grateful. For court satisfaction, we will produce the record. Kindly fix it after 2 weeks. Please, we will produce the record. Lordship can.
Yes, you will. You will have to. Since you are a party, we will definitely.
After 2 weeks, we will produce the record.
After settling the controversy between the government and the petitioner, then we will shift to you.
Okay. He's a third party beneficiary.
Yes, definitely. Only easy. Only if after we settle.
Yes.
The controversy between the state and the petitioner, then only come to you.
Absolutely. So in the meantime, we'll produce the record, Lordship. Yes.
You see, otherwise we know that probably your case was that this was never taken, or this allotment was never acted upon.
Yes.
And he's relying on notification from Assam.
Record.
I'm relying on the record from Assam, which Your Lordship has allowed me to bring a record.
Yes, that will come as an evidence so far as the fact is concerned. But then you do not want to go into merits. In this case, you do not want to go into that aspect and give a finding to that. We just.
So, Lordship, have it after 2 weeks. For your Lordship's perusal, we'll get.
Okay, hard London Council. Preparing for the parties at some length. Stop it a pace that production of. What record is this?
This is an inquiry report, Lord.
Records of
inquiry.
Inquiry conducted in pursuant to the order dated 26/3/2013 in WPC number 370 SH of 2011. Is necessary for proper adjudication of the matter, of this matter. What we started? It started with it appears. How do you say? It's all right. It's all right. Okay. Well, already held. Okay. Inquiry report held in pursuant to the order dated 27 is necessary for proper adjudication of this matter.
Lordship.
Yes. Stop.
2 weeks, no?
2 weeks.
The learned AG shall produce the related record on the next date of hearing. Stop. As prayed for, list after 2 weeks.
14.
In fact, there was not requirement of going for a detailed hearing in this matter. We should confine ourselves only to that. Only court wanted that at least the council should have.
Oblige.
Lordship,
Yes.
Lordship, here we are supposed to file the rejoinder affidavit, Lordship. Lordship, I'm praying for 2 days time, Lordship. Otherwise, the rejoinder affidavit is ready, Lordship. 2 days time maybe.
What is this matter about?
Lordship, this is regarding termination from service, Lordship. The petitioner here was serving as a school teacher under SSA, Lordship.
In a government aided school.
Lordship, SSA, under SSA.
And then
SSA.
SSA.
Lordship. And without
SSA,
notice.
In which manner you were appointed?
As a fourth teacher, Lordship.
No, and what is the manner and mode of appointment?
Lordship,
like usual selection process.
Usual selection process. Lordship.
Advertisement by the managing committee.
Managing committee.
Selection is also by the managing committee.
Lordship.
And the appointment is?
That is not the case.
No, what is the procedure? Forget about this. We are not just talking in the context of this course. We just try to understand what is the scheme in this thing. SSA, normally as per the procedure prescribed.
Lordship.
We do not know whether there is a procedure or not. That will be knowing. It is normally is advertisement by managing committee.
Managing committee, Lordship.
And this
subsequently approved, Lordship.
selection process is also by the managing committee.
Lordship.
State has no role there.
Subsequently, Lordship, the approval comes from the...
After you select a candidate,
Lordship.
you forward the name for approval.
Approval, Lordship.
Then there the role of the state starts.
Lordship.
Okay.
And there were some anomalies. After finding the anomalies, we have already
No,
cancelled.
we are not talking about this. Please analyze this. This court is trying to understand about the procedure. Now, so far as your case is concerned, you were selected by managing committee.
Lordship.
And your appointment was approved by the government.
Lordship.
Okay. And then, what is the term of the appointment under SSA? For how long it remains? It's a permanent.
Lordship, it was approved as a permanent, Lordship.
Now, by the very language, if you say about the scheme, we know that the continuance of service would be so long the scheme continues. So long this policy is in operation, your service also remains there. Until unless you are terminated because of the other aspects. So now here you have been terminated.
Lordship, here I am terminated without following the due process of law, Lordship, without any notice, Lordship, without hearing.
Even in spite of the fact that your appointment was approved.
Yes, Lordship. That is the basic, Lordship.
This is not the case, my lord. Here the case is, my lord, dispute is whether the petitioner or the private respondent is the fault teacher.
You are private respondent.
Yes, my lord.
And who is the managing committee of school?
Managing committee is represented by
Respondent number 8, Lordship.
Miss
They have been
Bigod.
newly impleted and they have filed their affidavit, Lordship.
Who is respondent number 8?
Respondent number 8 is the managing committee.
Managing
My lord,
committee, Lordship.
earlier the managing committee was not a part of the proceeding, my lord. Recently they filed a petition for implement of the managing committee, which was allowed by this honorable court. Thereafter, the managing committee filed an affidavit, that is respondent number 8, my lord, filed an affidavit in opposition, so to which they are to reply, my lord.
So there is no other private respondent than the managing committee.
I am the fourth teacher, my lord. I am the private respondent number 7. So I have filed my affidavit.
Who is number 8 then? Who is representing number 8?
My lord, number 8 is being represented by Mrs. B. Ghor.
Managing committee.
The new managing committee, Lordship. Who has,
Where is the council? It's not
My
there.
lord, she has, in fact, my apologies, my lord, she has called me up. She requested, because due to some personal, my lord, reason, she had to rush to Calcutta. So that was the, my lord, on her behalf, my lord, I'm just...
And what is the state role here, Mr. Abraham?
State role is that initially the appointment of the petition was approved. Subsequently, there was a new development, and after finding the anomalies of the appointment of the private petitioner, the state has already cancelled the appointment of the private
Without any opportunity. Once you give approval, now if you say that is approved, then you must give an opportunity. If you subsequently find that the appointment was made in violation of the norms.
that is, Lordship, our basic case, Lordship.
Because
that be the situation, then the role of managing committee private respondent has nothing to do here. If it is the admitted case of the government, you approved it, isn't it? So once we approve it, that means he requires us, of course.
I'll satisfy your lordship.
What for you need to file a rejoinder then?
Lordship, to the affidavit filed by the respondent number 8.
No, but then what is the need?
They have raised various issues, Lordship, in their affidavit, to which we need to rebut, Lordship.
Where is your order of termination?
Lordship. There is, in fact, Lordship, there is no intimation or there is no order in writing, Lordship.
So, but then that is what submission has come from the learned GA.
Lordship. Because
yes, Mr. Abraham,
Lordship,
where is the termination order?
Ground reality, Lordship.
You said that you found some anomalies and then.
Lordship, if I may, Lordship, the ground reality is that even today, Lordship, I am going to the school, Lordship, but despite that, they are not willing me to take the classes. They are not allowing me to.
If you are not a teacher, what is the question of your yourself being allowed to?
My lord, kindly see, my lord, because I was under the impression that my friend will be asking time for filing the rejoinder.
He is asking time. He is asking time. It is only the court is making the query.
My lord, even the board 4 teacher was added by him, my lord. It was never there.
4 teachers means?
In the appointment letter, my lord.
Could not follow. Just say us again. Tell us again. The appointment letter is enclosed with the writ petition.
Lordship, appointment letter is enclosed.
Appointment letter, yes. I have.
Lordship, it's at page 12, Lordship, of the
Page 12. And what is your submission with that? What did you say?
My lord, there was some manipulation with the appointment order, my lord.
Where is that? Page 12 is the order. Yes.
This is my affidavit.
Sure, affidavit.
This is my affidavit.
This is the writ petition. This is affidavit filed on. This is my affidavit. This affidavit and opposition as one number 7. Your affidavit, this one. Yes.
It doesn't say about any approval, but then it is only Mr. Abraham's submission that it was approved.
If I'm pleased to take a lordship to page 11 of my affidavit filed by respondent number.
Anyway, we'll just see. We'll just allow him to file a rejoinder.
This is my affidavit.
Respect for by Mr. Chandra, learned counsel for the petitioner. What is it? How much?
1 week's time, Lordship.
It take 2 weeks time, but then make it filed. 2 weeks time is granted for filing rejoinder affidavit to the for filing rejoinder to the affidavit of position of the respondent number 8. List accordingly. Yes.
Hello.
16.